The Subcommittee for the Indigenous Peoples of the United States will now come to order. The Subcommittee is meeting today to hear testimony on H.R. 437, to amend the Alaska Native Claims Settlement Act to exclude certain payments to Alaska Natives, elders, for determining eligibility for certain programs and for other purposes, introduced by Representative Young of Alaska. H.R. 6063, to provide for the equitable settlement of certain Indian land disputes regarding land in Illinois and for other purposes, introduced by Representative McCullum of Minnesota. The discussion draft ANS to H.R. 6181, the Samish Indian Nation Land Reaffirmation Act, introduced by Representative Gallego. S. 314, the Klamath Tribe Judgment Fund Repeal Act, introduced by Senator Merkley of Oregon. S. 559, to amend the Grand Ronde Reservation Act and for other purposes, introduced by Senator Merkley of Oregon. Senate 789, repealing existing substandard provisions encouraging conciliation with Tribes Act, introduced by Senator Mike Rounds of South Dakota. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chair and the ranking minority member or their designees. This will allow us to hear from our witnesses sooner and help members keep to their schedules. Therefore, I ask unanimous consent that all other members' opening statements be made part of the hearing record if they are submitted to the clerk by 5 p.m. today or the close of the hearing, whichever comes first. Hearing no objection, so ordered. Without objection, the chair may also declare a recess subject to the call of the chair. Hearing no objection, so ordered. As described in the notice, statements, documents, or motions must be submitted to their electronic repository at hnrcdocs@mail.house.gov. Members physically present should provide a hard copy for staff to distribute by email. Please note that members are responsible for their own microphones. As with our fully in-person meetings, members can be muted by staff only to avoid inadvertent background noise. Finally, members or witnesses experiencing technical problems should inform committee staff immediately. I will begin by recognizing myself for my opening statement. Good afternoon. Today's legislative hearing will be on 6 bipartisan tribal bills. H.R. 6063, to provide for the equitable settlement of certain Indian land disputes regarding land in Illinois and for other purposes, was introduced by our colleague, Representative of Minnesota, Ms. McCullum. Before forced relocation, the Miami Tribe of Oklahoma, Eel River, and Rio tribes signed the Treaty of Grossland of 1805, establishing that without the consent of all 3 signatories, the tribes had not ceded land south of the Great Lakes in the Wabash River watershed. Following the signing, the United States violated the treaty by placing land in the public domain and transferring parcels to colonial settlers without the consent of all the tribes. H.R. 6063 will extinguish the Miami Tribe of Oklahoma's land claim to Illinois land for 1 year to bring its case before the United States the Court of Federal Claims. Our next piece of legislation is a discussion draft amendment in the nature of substitute, or ANS, for H.R. 6181, introduced by Mr. Gallego of Arizona. H.R. 6181 will take approximately 6.7 acres of land into trust for the Samish Indian Nation, reaffirming a November 2018 decision by the Department of the Interior. The draft ANS we are deliberating today removes the reference to the November 2018 determination and reaffirms the application of the Indian Reorganization Act to the nation. In 1969, the Samish Indian tribe lost federal recognition due to a clerical error by the Bureau of Indian Affairs and regained federal recognition in 1996. Following the reestablishment of federal recognition, the nation has worked to restore its land base through the fee-to-trust land process. However, the 2009 Carcieri decision decided that the Secretary's authority to place land into trust applies to tribes holding federal recognition in 1934 and complicates the process. The Secretary approved the decision to take land into trust for the benefit of the Samish Indian Nation in November 2018 after a 9-year analysis in which they determined it was that the nation had fulfilled the criteria under the Reorganization Act. The discussion draft ANS of H.R. 6181 reaffirms the Indian Reorganization Act of 1934 applies to the Samish Indian Nation. Our colleague, Senator Merkley of Oregon, introduced the following two bills, S-314 and S-559. First, we have S-314, the Klamath Tribe Judgment Fund Repeal Act. S-314 will repeal the Klamath Tribe Judgment Fund Act to provide the Klamath Tribe's authority over judgment funds. During the termination era, Congress passed the Klamath Termination Act of 1954 to terminate the Klamath tribes. As a requirement of this act, the Klamath tribes submitted the final roll of tribal members to the Secretary of Interior to distribute the monetized funds of tribal land and property. At the time of termination, the Klamath tribes also had pending lawsuits to seek compensation for the mismanagement or misappropriation of tribal assets before the Indian Claims Commission. The Klamath Termination Act did not extinguish these claims, leaving tribal members on the final roll eligible for a share of the funds. Final judgment for the claims resulted in the requirement of congressional authorization and appropriation. Rather than addressing each claim, Congress passed the Klamath Tribe Judgment Fund Act to direct the Secretary to make per capita distributions. The distributions would go to all eligible tribal members and heirs based on the final roll and removed the authority of the Klamath tribes to self-govern over their funds. In 1986, the United States restored the federal trust relationship with the Klamath tribes. As the Klamath Judgment Fund Act did not account for the restoration of federal recognition, it continues to prevent the distribution of funds for the benefit of members and tribal priorities. S-314 will restore the Klamath tribe's right to self-government, the management of their funds. S-559 will amend the Grand Round Reservation Act to clarify the tribe's land claim authorities in Oregon by striking language that voids the tribe's right to bring forth land claims in Oregon. In 1984, the Bureau of Land Management, or BLM, identified a survey error from the 1800s that resulted in the BLM managing and holding in trust an 84-acre parcel of land. The tribe determined this parcel, the Thompson Strip, was unmanageable as of its narrow boundaries and proximity to land held by other interests. Through negotiations with BLM, Grand Round reached an agreement to transfer the Thompson Strip in exchange for 240 acres of land adjacent to the reservation. In codifying this land transfer, language was included in the act that wrongfully voided the tribe's right to bring forth land claims in Oregon. S-559 would correct the Grand Round Reservation Act to ensure that the Grand Round's relinquishment of land claims applies to the Thompson Strip. Next, we have S-789, introduced by Senator Rounds of South Dakota. S-789, the repealing existing substandard provisions encouraging conciliation with Tribes Act, would repeal 11 antiquated federal laws about American Indians and Alaska Natives. While today's laws promote tribal sovereignty and self-determination, at its founding, the policy of the United States to forcibly remove and assimilate tribal communities. S-789 will address several discriminatory federal laws that reflect the history of violence perpetrated against American Indians and Alaska Natives by the federal government. Lastly, we will hear H.R. 437, introduced by our late Dean Young of Alaska, to amend the Alaska Native Claims Settlement Act to exclude certain payments to Alaska Native elders for determining eligibility for certain programs. In 1971, Congress passed the Alaska Native Claims Settlement Act to address land claims in the state of Alaska. Under the settlement agreement, the federal government transferred 44 million acres and $962.5 million in compensation funds to the newly established Alaska Native corporations. ANCSA expressed that no provision within 2C would diminish Alaska Natives' rights as citizens of the United States and the state of Alaska or the obligation of the United States and the state of Alaska to protect the rights and welfare of Alaska Natives as citizens. Following this provision, ANCSA was amended in 1976 to exclude the first $2,000 Alaska Natives received from ANCs in the determination of eligibility of the recipient for need-based federal programs, and this has remained unchanged. With further amendments, Congress failed to exclude settlement trust in such funding to determine eligibility for need-based federal programs, forcing Alaska Native elders to choose between receiving the settlement trust benefits or qualifying for need-based federal benefits. H.R. 437 would amend ANCSA to exclude ANC benefits provided to Alaska Native elders when determining eligibility for need-based governmental programs. I want to thank our witnesses for joining us, and I look forward to hearing testimony this afternoon. I would now like to recognize Acting Ranking Member Obernolte for his statement from the state of California.
Well, thank you very much, Madam Chair. I am really looking forward to our hearing. This will be our first hearing that's hybrid since the start of the pandemic. It's very nice to see people here in person, and hopefully health conditions will allow us to continue to do that. Also, this hearing is very poignant for me. Obviously, this is our first hearing without our Dean, Don Young. I'm deeply honored to be sitting in his seat here. He did so much for Indian country, and certainly I've got some big shoes to fill. And it's very appropriate that our first piece of legislation that we're considering is one that he authored. It's H.R. 437 to exclude amounts provided to Alaska Native elders age 65 and older from the Alaska Native Settlement Trust when determining eligibility for some government benefits. When Congress established the ANCSA in 1988 to authorize Native corporations to establish settlement trust, it did not exclude those benefits for determining eligibility. And according to several ANCs, and I'm sure we'll hear that testimony today, this discrepancy between the types of income from ANCs can place many Alaska Native elders in the position of having to choose between accepting settlement trust income on the one hand or qualifying for government assistance on the other, and obviously that's not a situation we would want to put anyone in. The second bill on our agenda, H.R. 6063, seeks to resolve the purported land claims of the Miami Tribe of Oklahoma by conferring exclusive jurisdiction over the tribe's claims to the U.S. Court of Federal Appeals. Now, it's worth saying that legislation like this bill is relatively uncommon due to the finality of the Indian Claims Commission on Historic Lands prior to 1946, and I'm hopeful that this committee will exercise care and discretion with its consideration of this bill due to the broader implications that this might have and the impacts it might have on gaming. Our third bill, which is discussion draft ANS to H.R. 6181, would reaffirm that the IRA applies to the Samish Indian Nation. This draft ANS would, on its face, provide for the applicability of the IRA to the Samish Indian Nation. Now, it's my understanding that several tribes in Washington have voiced concerns over the implications that this bill has introduced and the ANS might have on their treaty rights. I'm sure we'll be hearing from them today. While the ANS would not directly ratify the 2018 BIA decision and the accompanying Carcieri analysis, as the bill as introduced would have done, I am still concerned by the use of the word reaffirmed, and I am worried that it might be construed to mean that what is being reaffirmed is the DOI decision. So hopefully we can clarify that. One way or the other, I think that this committee should exercise caution in consideration of this bill due to the implications on what are now settled treaty rights in case law spanning the past 40 years. Based on previous testimony from the Department of the Interior and the testimony that we have received in writing for today's hearing, I think that all parties would benefit if we request that the Department of Justice provide this committee with its views on whether or not H.R. 6181 and the ANS would affect the DOJ's legal rights in treaty litigation. And so, Madam Chair, I think that might be something that we should look into. Our fourth bill, S314, would repeal the Klamath Judgment Fund Act and require that the remaining $600,000 in the fund be transferred to the Klamath tribe. Madam Chair, you did a wonderful job summarizing that. I think that's it's only fair that we consider that. Our fifth bill S 559 will amend current law to reflect that the Grand Ronde tribe's extinguishment of land claims only applies to an 84-acre parcel of land known as the Thompson Strip. Now, it's my understanding that two tribes have expressed concerns about the gaming prohibition language consistency with the stated intent of the bill, and I'm hoping that this is something that we'll be able to discuss in the hearing today. And then finally, our last bill, S 789, would repeal 11 statutes related to the treatment of Indians. If you read those statutes, I find them undeniably racist and deeply personally offensive, and I'm very happy that we are considering purging the federal code of those statutes today. So I want to thank our witnesses for joining us today. I'm looking forward to hearing their testimony, and Madam Chair, I yield back.
Thank you, Ranking Member. I ask unanimous consent that Representative Schrader of Oregon and Representative Mullen of Oklahoma have permission to sit on the dais and participate in the hearing. Hearing no objections, so ordered. Now I would like to transition to our panel of witnesses for today. Before introducing them, I will remind non-administration witnesses that they are encouraged to participate in the Witness Diversity Survey created by the Congressional Office of Diversity and Inclusion. Witnesses may refer to their hearing invitation materials for further information. Under our committee rules, oral statements are limited to 5 minutes, but you may submit a longer statement for the record if you choose. When you begin, the on-screen timer will begin counting down and will turn orange when you have 1 minute remaining. I recommend that members and witnesses joining remotely lock the timer on their screen. When you go over the allotted time, I will gently nudge you to wrap up your statement. After your testimony is complete, please remember to mute yourself to avoid any inadvertent background noise. I will allow the entire panel to testify before we question the witnesses. The chair now recognizes Ms. McCullum to introduce the first witness.
Thank you, Madam Chair, and greetings to all my subcommittee members. I am pleased to introduce today the Miami Tribal Chief, Doug Langford, and he's going to be testifying in support of H.R. 6063. Chief Langford has served the tribe since 1998 and as tribal chief since 2012. And before that, he was sub-chief. In his spare time, Chief Langford serves as the tribal IT director and vice chair of the Intertribal Council of Northeastern Oklahoma. Chief Langford has worked to enhance healthcare and elder care for the tribe, sustainable farming on the tribe's reservation, as well as strengthening the tribe's connection to its members in Kansas and in Indiana. Chief Langford has also worked to enhance the tribe's historic relationships with the Miami University in Oxford, Ohio, and the development of the Miami Center at that school, which advances education in Miami languages, culture, and serving dozens of Miami tribal member students. Now, Chief Langford's also a proud father of 2 boys and 8 grandchildren. So, Chief, welcome to the Subcommittee of the Indigenous Peoples of the United States. We're proud to have you here.
Thank you.
Thank you, Madam Chair.
Thank you, Representative McCullum. The chair now recognizes the Honorable Doug Langford, who is the chief, as we've just heard, of the Miami Tribe of Oklahoma.